Do you really need an attorney to prepare your deed? So I'm going to showcase an example of what happened in my office today so you can decide whether it's worth paying the extra money to have an attorney prepare your deed versus trying to do it on your own, or maybe have someone else who's not quite as qualified prepare the deed for you. So here's the facts. Dad owns property. Dad ends up getting into a relationship with a woman who he's with for several years. So dad decides to add this woman on to the deed. Now, when they do the new deed, it simply lists the two of them by name as owning the property. So as an example, Tom Jones and Shirley Wright as grantees. That's all it says. The grantee is the person receiving the property. So it just has their name, no reference to their relationship, and no words on the face of the deed as to how the property is actually owned. Is it owned jointly? Is it owned in individual shares? So if a deed is silent, meaning it doesn't state that the property is jointly owned, and again, the key words are joint ownership with rights of survivorship, then the individual owners just own their own undivided interest or their own share of the property. So when you have two people on the deed, each one owns their own separate 50% share. So when dad added his girlfriend to the property, dad went from owning 100% of the property to now he owns 50%, girlfriend owns 50%. Fast forward. Girlfriend passes away. She was never removed from the deed, so she passes away. And then 2 years later, dad passes away. Dad has a son, his sole surviving heir. So his son is going to take any assets that dad owns upon his passing as his own. Now, in order to do this, if there's assets that don't list beneficiaries or they aren't in a trust, these assets are going to have to go through the court process called probate so that they can legally pass to his son. The title to the home simply had dad and his girlfriend. So there's no beneficiaries on this title. It's not a ladybird deed that Florida lets you use. It just had two names. So dad's name is one of them, right? So this property does have to go through a probate in order to pass to anyone else. Because the deed, again, just listed dad and the girlfriend, dad owned, again, 50% of the property. So dad's 50% is all that can be probated in dad's estate. The girlfriend who died before dad, her 50% actually went to her estate. So there's another 50% of this property that nothing can be done with unless there's a probate. I bring this up because the client who called in was very excited because the girlfriend who passed away, she has two children who want nothing to do with this property, and they were willing to sell it to my potential client at a very good rate. They wanted nothing to do with it at all, so they were willing to sell it for a very low price. So the client who called in figured I could just buy the property from the girlfriend's two kids. They want nothing to do with it. And then all own the property 100%. Super easy. My dad died second, so it just needs to go into this probate. But since they're selling their interest to me, then I'm going to own 100%. That's not how it works. Because the deed wasn't jointly owned, meaning when the girlfriend passed away, her share didn't pass directly to the dad. We actually have two separate owners, whether they're alive or whether they're dead. The difference being is obviously while they're alive, they own the property in their own name. After they pass away, it actually becomes part of what is called their estate under the law. So their 50% is automatically part of their estate. So because of this, I had to let this caller know that the only way for him ever to legally own on the title 100% of this property is 2 probates have to be done. You know, he can buy out the people that have the interest in the girlfriend's share of the property, but there's no way he can own 100% of this property without the need for 2 probates. Here's the tricky part. The kids of the girlfriend wanted nothing to do with probate, right? So now he's in a situation where, in order to fix this so that the title can actually be correct, especially if he wants to do something later on, like sell the property, he's now going to have to bring 2 probates, one for his father and one for his father's girlfriend. I highlight this example because one of the things that we discussed during the call was it was not supposed to be worded that way, the deed. And I see this all the time, meaning the intention was for the survivor to own the property, the survivor of the dad and the girlfriend, so that whenever that survivor passed, then the property would just pass to their heirs, their kids, even if a probate was needed. But because whoever drafted this deed either inadvertently left it off, or left it off for a different reason, they didn't write joint tenants on the deed. And because they didn't write joint tenants with rights of survivorship on the deed, they made it so that when either owner died, a probate would have to be done, and then when the other owner died, another probate has to be done. Now, sometimes this might be what's wanted, but when it's not wanted, and you don't know that those magic words have to be on the deed, then there could be lots of trouble down the road. So it's really important to, one, make sure that the deed is prepared in a way that it actually is meeting your goal or what you want to achieve. Do you want separate shares owned? Or do you want to make it so that if there's more than one owner, the survivor ends up owning all the property? And then also you need to make sure that the right wording to make sure that happens is on your deed. So this is why you might want to check with a qualified professional before you simply prepare a deed yourself or have a friend or someone else do it to try to save a few dollars. All right, so I hope this sheds some light on one issue that could come up with deeds. If you have any other questions about deeds or estate planning, asset protection, elder law, and you're in Florida, please don't hesitate to reach out to us. We're at Cause Law Firm, the non-stuffy attorneys, and the link is in my bio.